I want to tell a cautionary tale about personal guarantees because so many business owners that I sit with in my boardroom don't even know how many personal guarantees they've signed. In fact, when I ask the question, have you signed personal guarantees? Most will say no. Now, the start point is read the terms that you're signing. Look for not just scope of service and how much you're paying. Look for liability for payment. Look for guarantees. Look for things that might appear to be a personal guarantee, because not all personal guarantees start with a heading personal guarantee. Sometimes it's liability for payment and you're going to pay within 7 days of invoice, and then all those kind of generic terms. And then right there, it'll say the person who signs these terms personally guarantees the obligations of the customer, and then you sign it. So the start point is read the terms, understand whether or not there is a guarantee, and, strike it out. Actually, I've seen so many cases where personal guarantees have been struck out of the terms and the parties have continued to trade on that basis. Have the conversation. And if you can't get rid of the personal guarantee, which I accept in some cases is possible, have a register. Understand, hey, look, these are all the guarantees that I've signed, because there are organizations like Bunnings and Placemakers who they will always have personal guarantees in their terms. You need to understand if you are incurring these debts, it's not just the company's liability, it's your personal liability, and that will follow you. If that company fails, it gets put into liquidation. There's a pandemic that nobody expected. You will be liable for the cost of your company. It's not the only instance I've seen this, but I had a client who had exited a company. He had decided to walk away. He actually gave his shares away. And then 3 years later, it went into liquidation. And a very large building supplier then made demand on my client for $500,000 under his personal guarantee. He hadn't been involved in the company. All this debt was incurred after he resigned as a director, after he gave his shares to the other shareholders, and he was stunned because he had assets. That building company came after him because he was the frog on the rock. He had properties that they could see and they knew they were going to get paid. So what he could have done is, at the time he resigned, he could have done two things. He could have, one, obtained an indemnity from those who saw the hope they wanted to continue trading. He could have indemnified himself from them, so if he ever got demands, he can come to them for payment. But he also, and probably more effectively, could have withdrawn the guarantee to the creditor. He could have said, I'm no longer going to guarantee future suppliers. You can't withdraw for any past debt because that's done, but you can withdraw your guarantee for any future trading. So then those building companies can then renegotiate any other security or personal guarantees they want with those who continue to exist in the company. But knowing what guarantees you have is always the start point, and it's the point in which most directors fail, in my view. So have a good understanding of your personal obligations and then have a strategy to deal with them.